Your best friend you talk to once in a while. Meet your new best friend because she's going to help you get to the end of this thing without ending up in jail. We look at that as a failure. Probation is not so we can ultimately jail you. If I wanted to jail you, I wouldn't have put you on probation. I would have just put you in jail.
Okay.
Good morning, Mr. Huziak. Counsel, your parents.
John Wells County Attorney on behalf of William Huziak, who's my left. Please identify yourself. My name is William Huziak.
Thank you. All right, Mr. Huziak was sentenced on April 23rd on visibly impaired.
That's correct.
All right, you've seen the paperwork I'm looking at, I assume?
Yes, he's guilty of those violations.
Okay.
He has made progress, but he I use a term, but he doesn't have a pocket perch. He
Okay.
has to be more aggressive in getting a job. Obviously, the transportation is the issue, the inability to pay fees with the court and also the Secretary of State, and but that things will mercy these.
Okay.
I also feel that this gentleman would benefit from intervention from a spatial worker.
Okay. Okay. So you still have a steady employment?
No, I haven't had a job since the middle of March.
Okay.
I took your advice on, get a job and nobody had never responded back to me.
Okay.
I just got some information out here and some jobs. I probably got 10 applications out there right now.
When you pointed out here, are you talking from Mr. Taylor downstairs?
Yeah, you said about that hotel here on the street.
Yep. 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 Okay.
Judge, I believe that you can knock down some of the debt of this court by additional work ordering days. And even if you, that it's probably one of the best ways that you can.
Yeah, that's always an option you can talk about downstairs is what our payment options are. But to be perfectly blunt, the money's not my concern on this. It's the other stuff I told you to do. The testing, the substance abuse treatment, those are the big ones for me. Whether or not you pay your money doesn't help me sleep at night. If I know you're getting help for what I see as a substance abuse problem, that helps me sleep at night because I don't have to worry about you out drinking and driving.
Yeah.
You follow me? So those are the big ones for me. Here's when you're on probation, you're always at risk of being violated and ending up in jail. You understand that? The best way to avoid that is to do everything you're supposed to do. The second best way is if you're having problems, stay in constant communication with probation. So if you're standing here again, she can say, Judge, I'm talking to him on a weekly basis. He's trying everything I'm suggesting he do. He's making a good faith effort. He's just got a lot of struggles right now. Okay? I'm going to bet that you haven't contacted her since you walked out of here for sentencing.
That was it.
We've reported.
Yeah, but I mean, you're not reaching out to her. You're just showing up when you're scheduled to do so. Okay? Now, your best friend you talk to once in a while. Meet your new best friend because she's going to help you get to the end of this thing without ending up in jail. Because I don't think her recommendation is jail today. What's your recommendation today?
We like to adjourn this for review, maybe just to give them some time to get in compliance.
When's our next review?
It's August 20th at 8:30.
All right, so let's do this. August 20th, we'll meet again. I want you on track with the testing and the treatment. And if you can't find someplace you can afford for testing and treatment, that's when you talk to her and see if she can help you find something you can afford. Okay? And just keep pounding the pavement. I mean, you've found a job before and you got to work at finding a job. So good luck with that. But if you haven't talked to Mr. Taylor recently, talk to him again to see if he's got anything that fits your skill set. Any questions? All right. I'm sorry, Emily, was that August 20? All right. And Mr. Huziak, understand, she doesn't get points when she gets me to put somebody in jail. We look at that as a failure. Probation is not so we can ultimately jail you. If I wanted to jail you, I wouldn't have put you on probation. I would have just put you in jail. All right? So let us work with you to get you successfully completed. All right, good luck. What's the next one, Mr. Graziani?
The next one is Damari Filson.
Filson with an F? Or a PH?
PHILSON.
Come on up, Pilson. Fifth violation. There aren't too many people that avoid jail on 5. If you know, what's the status of your client's license?
He It appears he's suspended, is that correct, sir?
Oh, yeah.
And, as a result, he's avoiding any additional suspension.
What's it take to get him back on the road, do you know?
Judge, I believe that, he's got what's known as a hard suspension. Is it unpaid tickets or?
I got a paid ticket,
So it's a top suspension, Judge.
and then I paid a $45 reinstatement fee and then
Who do you owe money on? Where's the ticket at? What do you owe
I'm not aware of how much I owe. I just got one ticket.
them? But that's the only thing that's stopping you from getting your license back?
Yes, sir.
Well, you got to get your butt down to 33rd then to find out what they can do for you. They might be able to put you on a payment plan, give you some kind of community service hours or something.
That's
Okay.
Judge, despite some of these setbacks, he's made tremendous progress. He's been working for approximately.
Okay, hold on. I can either read this letter or I can listen to what you've got to say, but I can't do them both at the same time. All right. Now I can listen to you, Mr. Graziani.
Made some progress. He's been gaining some flooded mission bread.
Yep,
He's also seeking another position so he could get ahead.
I saw that. Yep,
So that, I hope you take that.
yep. So I'm assuming that's a guilty plea to the violation.
It is, Judge.
Okay. So you picked up 2 new DWLS charges. Where at? Drove with license suspended charges.
oh, yes, I was on my way to.
No. Where are they at? Which court? Here? All right. Oh, okay. And it looks like both those got pled down and you owe us money on them, right?
Yeah.
Okay. All right. What's your recommendation, Ms. Trolley?
4 days on the work program with discharge.
All right. Anything else, counsel?
Judge, again, I hope you take consideration progress.
I am, and that's why he's not going to jail today. Yep. You understand that?
Yeah.
5th violation. There aren't too many people that avoid jail on 5.
How much time are we looking at?
I'm gonna do 3. I'm gonna she said between 2 and 4, and between 2 and 4 is 3. So 3 days work program. And then we'll turn you over to collections. Do you have a payment plan on all these cases?
I'm going to be putting approximately $200 down.
I can pay 200 today.
Just get, before you leave, have a plan in place, all right? Okay, good luck.
Okay.
Hold on, let me cut you off. The recommendation is 30 days on the work program or 10 days in jail. So it's not hours, it's days, right? But go ahead. Where's you working at?
Thank you. He works swing shift hours.
Steel mill,
Yeah, and he can't drive because this is 2 and 7.
right?
But he's straight, for example, can you guys tell? This morning, he's texting me saying that Uber won't come. And, I'm gonna halfway here, and then he's kind of, he can't.
Right.
And so I said, well, call it, and then at some point we were getting caught, but he's at the mercy of things like that. So I think it could be a hardship, that's what I'm saying.
Right.
He will do it if you order it, but we ask that he modify it.
I'm gonna give him the choice, but this is a 93-day misdemeanor. It's your 3rd one. So, and I don't have to tell you, counsel, I'm sure you've told him, a lot of places in the state, you would have gone to jail already. Yeah, yeah. So it's your choice. We'll do the community service days, or excuse me, the work days or the jail days, and I'll let you pick either one. And if you want to do the jail days, I'll even give you a little bit of time to set things up on the job so you can go do your jail and come back to a job. So I'm not saying you got to start your jail time right now. So okay, understand, because I don't think you were in here earlier. You pick the days, but we're going to hold you to that schedule. So if you pick, for example, if you pick the next 10 Fridays and you don't show up, we're not just going to say, okay, we'll see you next week. We're going to charge you to reschedule. And at some point, I'm going to get tired of rescheduling. Then I'm just going to say, well, you still owe me 10 days and that's going to be in jail. Okay?
Off days and stuff.
But you pick the days, but it's not a dentist appointment. You can just call and cancel the day before. Okay? So anything else before I sentence? I think so. Yeah. Anything you want to tell me, sir, before I sentence?
That would actually be hard to get that. Thank you.
I understand that. But, and I'm not saying this because I'm trying to rub your nose in this, but the reason you can't drive yourself is because of your bad decision making. This wasn't an accident that caused you not to be able to drive. You made some bad decisions. Probation is designed to help you make better decisions in the future. That's why, I mean, if you look at these recommendations, I mean, I don't even know if you were in here for, if I want to punish people, I can put them in jail, right? I put people on probation because I want to effectuate a change in behavior. That's what this program is designed to do, is make this third drinking and driving offense your last drinking and driving offense. All right. So that's why we're requiring the treatment. So with all that, I'm going to adopt in full the recommendations you went over with council, 1 through 10. Those are now court orders. Fines and costs total $1,500. Before you leave the building, I either want that paid in full or a payment plan in place so we know we're going to get it payments or however you work out downstairs. Any questions? Council, anything else? Have a nice day. Good luck to you, Mr. Yanez.
Succession of trust. And very interesting, brought out on recross was, he told them, he said, yeah, 20 minutes ago, I used cocaine. Judge, it's possession of cocaine now. There's some, perhaps, that's circuit court level. If so, I'm going to learn something new today.
Yeah, I know that. What's the name?
John Palmer.
Palmer?
Yeah.
All right. All right, appearances on Palmer.
Good morning, Your Honor. Stephen Gale, on behalf of the people.
Hey, good morning, Your Honor. Regular Defender Service by University of Florida, 86643 on behalf of Mr. Palmer. Mr. Palmer, can you hold the judge reading?
John Bolton.
Thank you. Is it Drewer?
Sure.
Spell it.
H-R-O-U-R.
C-H-A-H.
R.
Shore? Shuror. Shuror. Like roar. Shuror. Shuror. Got it. Okay. All right, we ready?
Yes, sir.
All right. Sit down. Make yourself comfortable.
Preliminary.
Yeah.
Your Honor, we have a Michigan State Police crime lab developed from Northern County, which contraband confiscated in this case. The report has been marked as proposed exhibit 1. It shows that the substance was tested, and in fact, this cocaine, I shared it with counsel. I believe we have a stipulation that.
That's correct, Judge.
Thank you. And you don't have to jump up to talk to me.
I may have put your Honor.
Sure.
Just for the record,
Thank you.
I'm sorry.
You already got it?
I would just like to note that the amount of that substance is about a quarter of a gram, less than 1 gram.
Okay. Okay.
Thank you, Your Honor. So one witness example, we'll call Officer Gardner.
Officer, all the way up front. Raise your right hand. Swear or affirm to tell the truth, the whole truth, nothing but the truth. Come on up. Watch your step on my incline ramp. Make yourself comfortable in that chair. G-A-R-D-N-E-R? G-A-R-D-N-E-R. Guard. Yeah. When you're ready, Mr. Capel.
Morning, Officer Gardner. You work for the Romulus Police Department.
Yes.
Taking you back in time to October 5th of 2025 in the afternoon around 5:30. Were you working as a police officer?
Yes.
Where were you at that time?
At that time, I was attached to an address on Biddle.
Do you remember the address on the bill?
I don't remember it off.
If you saw the report, would it refresh your memory? Yes, put the address on Middle Street.
Yes.
Your Honor, may I quote from the
Please.
going away this page 2 of the police report. Officer Gardner, just review it and tell us when your memory is refreshed.
Okay.
What is the address on Biddle?
9526 Biddle.
Now, at that time, are you in uniform or plain clothes?
In uniform,
Are you in a marked or unmarked vehicle?
in a marked vehicle.
Are you alone or do you have a partner?
At that time, I was alone.
Talk about Middle Street. Why were you at Middle Street?
We were dispatched to a male slumped over the wheel of a white Ford Bronco next to park next to the dumpster.
How much time passed between when you received the dispatch as to a man slumped over the wheel on Middle Street and when you actually arrived?
I don't know the exact time.
Approximately.
Under 5 minutes?
On that day that you meet a gentleman named John Palmer,
Yes.
you saw John Palmer again, you think you recognize him?
Yeah.
Tell the judge whether you see John Palmer.
I,
What is he wearing?
a gray hoodie, black pants, sweat shoes.
Noted,
The record reflect the witnesses identified the defendant John Palmer.
noted.
Where do you first see the defendant John Palmer?
I'm sorry.
Where do you first see the defendant John Palmer?
He was in the white Ford Bronco,
Is he alone or does he have a passenger?
alone,
Is he behind the wheel or is he in the passenger area?
behind the vehicle.
What do you notice, if anything, about the defendant?
He was slumped over the wheel. I also observed a needle on his slab at that time.
What was that, sir?
I observed a needle on his slab at that time.
Was he awakened at any time?
After I knocked on the window, he woke up.
How many times did you have to knock on the window?
I don't remember the exact amount, probably like 2 or 3.
So what do you notice, if anything, regarding John Palmer at this point?
He woke up, took what was off of his lap, placed it to the left of him, and rolled down the window.
What did he do with it?
He took the objects that were on his lap and placed it on the rocks to the left of him.
Can you tell the judge what object you're referring to?
We recovered a capped needle and a Michigan lottery ticket that was folded up containing a brown powdery substance.
But based on what you saw, did you form any inferences as to what might have happened?
Yes.
What inferences did you draw?
At that time, we inferred that he had taken drugs and was experiencing symptoms from that.
You use the pronoun we. Who's the second person?
Officer Green was on with me.
Solomon Green? What happens to these items that you just described and judge told me?
After they were photographed, we collected them and they were placed on evidence.
What happens after that?
These are their lab sheet, there's some issues, the lab be tested.
You mentioned lotto folds.
Yes,
Do you have any experience with lotto folds in your line of work?
there are 3 that we learned that typically it's used as a sword for, drugs, powder.
Thank you so much. Nothing further, Your Honor.
Counsel, your witness.
Bell Street, what city is that located?
Right.
Thank you. Thank you, Judge.
Okay, Officer Garvin. So you were dispatched for a welfare check.
Correct.
The dispatch related that there had been a 911 caller.
Correct.
And that 911 caller had said that a man had been slumped over his steering wheel for several hours.
Yes.
You understood your job to be checking on this man's welfare.
Technically, Your Honor, that's not relevant. That's what she does.
She's already answered. Go ahead.
And that's reflected in your report? Yeah. And you weren't there for a fight? No. You weren't there for any other criminal activity? No. When you got there, you saw that a man was unconscious.
He was slumped over the wheel.
Okay. Was that yes or no, miss?
Yes.
And you saw a needle in his lap?
Yes.
And you recognize that to be drug paraphernalia? And this led you to believe that he could be unconscious due to drug use?
Yes.
And when your partner asked the questions of his drug use?
Yes.
And you asked those questions because you thought you might overdose?
Your Honor, we would strike the answer of unconsciousness. She's not in a position to tell you that. She's not an ER doctor. She can tell you he wasn't awake, but how does she know whether he was unconscious?
Response.
Asking her what she observed. She can observe whether or not somebody is awake or conscious or what have you.
But this distinction between being conscious.
I'm not asking her for a mental health.
Okay, we're going to talk one at a time. I'm sorry, go ahead.
I know it's not a really important point here, but there's a distinction between being unconscious and being asleep.
I'm not asking her to make a medical conclusion, Judge. I'm just asking her what she observed.
Okay, I'll allow it. I can weed the chaff from the wheat.
And you were asking those questions because you thought he might overdose.
Objection relevancy. Either had drugs or didn't have drugs.
What's the relevance?
Judge, I'm asking questions that fall within the statute that my client is charged under. And I'm allowed to ask those questions.
Has to be relevant, Your Honor.
Yeah.
And it is relevant.
Then explain why it's relevant.
It's relevant because this was a welfare check. Somebody was calling because they were concerned for my client's well-being. And I'm trying to gather information about what state my client was in.
Then ask her what state your client was in. You're asking her the reason she asked these questions. Those aren't relevant. The reason she's asking her questions aren't relevant.
And, would you offer my client help?
Election relevance,
I'm
doesn't
asking,
matter.
it does matter. I'm asking her what happened in this matter and how this, situation ended, Judge.
What's it matter? He's charged with possession.
He is charged with possession, Judge, but it's also, what he was using those, drugs for. I have stipulated to the lab report. And it matters how those drugs are being used.
How does that matter?
Judge, I will
Does he have a prescription for the cocaine?
not say that for cocaine drug, but it will be relevant in my mind.
Let's be relevant at this point.
It is relevant at this point.
Then you have to explain to me how.
It's relevant because under the statute, there is a Good Samaritan, exception to this rule.
That protects the Good Samaritan.
I'm trying to get answers from Officer Gardner to show that that was a warranted, call for Mr. Palmer's welfare. And Mr. Pavlin is not allowing me to do so.
Okay, but doesn't that statute protect the Good Samaritan?
No, the statute protects the person who is using.
There's no law of that. In fact,
Yes, there is. It is.
I didn't interrupt you.
I'm sorry, I thought you were done. You took a pause.
Go ahead.
There's no law of that effect. Now, there is some case law where if you have dope, you take it to the police station, you can relinquish. In this case, he fell asleep with the drugs on his person. How does that make him a good Samaritan? He's a bad Samaritan.
May I please cite the law?
Sure.
It is 333.7403, subsection 3A. May I read it into the record?
I'd rather you hand it to me because I don't do well when people read to me.
If I may have.
Yeah. So your argument is that Mr. Palmer's been presented for assistance by another individual?
Yes, that's correct. And it's relevant that I asked Officer Gardner if she procured assistance because that's what it was called.
Any argument to that?
I mean, how can staff?
Okay, counsel, I've asked him a question.
Anything related to this witness is hearsay. I know this is tangential. It's all hearsay. We can't cross-examine anyone who called, but it's not even relevant. If counsel were correct on this, you could have a drug kingpin who falls asleep at the wheel, and all the drugs found in his car can't be admitted. That's nonsense. There's no law of that.
Yeah, well, let's argue the language of the statute. The statute says an individual who seeks medical assistance for himself or herself, or who requires medical assistance and is presented for assistance by another, has an exemption. Her argument is because of the dispatch call, Mr. Palmer was presented for assistance by another.
First of all, we have the hearsay issue. She can't overcome. There's no doubt about it. Statement made out of court for truth of the matter certain, so we don't know why anyone called. You might just have somebody speculating. We don't know. Somebody sees a person slumped at the, you're gonna call. It could be an unconscious person, it could be a guy who's been shot, it could be all kinds of circumstances. This unknown caller, Judge, doesn't have personal knowledge, can't tell you why the guy was slumped behind the wheel.
Would you agree with me, counsel, that the reason for the call is pretty important for your argument? And would you also agree you can't establish that today at the probable cause hearing?
Check. Probable causes.
That's a yes or no question, counsel. How are you going to establish it without the person that called?
Would you like me to answer yes or no, or would you like me to answer?
I'd like you to answer yes or no. Are you going to be able to establish that today?
Yes.
Good luck. How are you going to do it?
Judge, I'm trying to, again, procure answers from Officer Gardner as to why she was there, how she was able to assist Mr. Palmer in doing those things. She has answered affirmatively
That doesn't do it though.
that she was there.
Presented for assistance by another individual. So she can't tell you why that individual called.
Judge, the purpose of this law is for.
All right, counsel, I understand the purpose for the law. That doesn't help us today. Today's a probable cause hearing.
understand that the purpose also for the probable cause hearing, yes, is to assess.
Don't lecture me, counsel.
Um,
I've been doing this longer than you've been alive. I understand the purpose for a probable cause hearing. Okay?
And Judge, I would like to point out that Mr. Kaplan did open the door to the 911 call in his direct examination. I did not object to hearsay to him, and he did not object to hearsay when I asked the question of what the 911 caller had
It
said.
wasn't hearsay when he used it, counsel. It was meant to explain why she went to Biddle Street. That's not for the truth of the matter.
I understand, Judge, but,
Back to your questions.
and did you call for help?
Did we call EMS?
Yes,
To petition the bill, yes.
yes. Okay,
What'd you say to what, Dick?
To petition him.
Thank you.
okay. And Rollins Police, or, excuse me, not police, fire department, they did respond, EMS came?
Yes.
Okay, and then they took him to the hospital?
Yes, we're, Officer Green petitioned him.
Okay. And you did that because you believe that he needed that help?
For mental illness, yes.
Okay. Thank you.
No more witness questions for this witness?
No.
Any redirect?
Very good. Make you adapt to. You had other occasions where you were summoned, dispatched to an area of a person sleeping or slumping behind a wheel.
Yes.
Are there many circumstances that could cause him,
Yes.
like physical illness,
Yes.
like overdosing,
Yes.
like using too many drugs,
Yes.
lack of sleep?
Yes.
Any recross?
Yes.
Go ahead.
You search the vehicle, right? It's,
Actually, outside the scope of my back.
Judge, it's relevant, I'm just trying to lay a little bit of foundation.
But it's outside the scope.
May I approach this witness?
Sure. Morning, counsel.
Do you recall writing a report?
Yes.
And do you recall, stating in your report?
We have checked, the report is here saying she could be impeached if she made an inconsistent statement.
Okay.
Anything in the report is here.
Do you recall evaluating whether he needed medical attention due to the state that he was found in?
Checked and relevant.
It's within the scope of what he asked.
I'll allow it.
Yes. Okay, and that's consistent with your report, is that correct? Okay. And so you were trying to help him, not just for his mental illness, but for the state that he found him in.
We were trying to establish if he needed medical assistance or the state he was found in.
Okay, and you determined that to be in the affirmative, is that correct?
For possible overdose, no, he did not get any medical attention for that. Medical attention was called for the petition, the comments he made while in back.
Do you recall continuing to monitor him because he was trying to ensure that he was still alert and responsive?
Checked and relevancy.
Again, this is within the scope of,
I'll allow it.
were you trying to ensure that he was still alert and responsive?
Yes,
And that's because of the state that you found him incorrect.
as well as because he told us that he had used 20 minutes prior.
Okay, so that's a yes.
Yes.
Thank you.
He told you that he's
Hold on. How many shots we gonna have at her?
supposed to no redirect, but if something new is opened up, don't have a kid,
No.
make it.
And,
People are.
no other witnesses? You can step down off the guard and watch your step on my rant. Safe to assume we don't have any defense witnesses today?
No.
I'm ready for argument.
Thank you, Ryan. Very simple case, happens every day, comes in any large municipality. People fall asleep in their cars. Why? Why do people fall asleep in their cars? Yes, sometimes they play. Sometimes they're meditating. Sometimes they overdose. Sometimes they consume too much alcohol. Sometimes they're hiding. In this case, the officer responds, they see this John Palmer gentleman slumped behind the wheel, and they don't know, Judge. They acted appropriately. I mean, the guy could have been in the throes of overdose where he needed medication. We don't know that. But we do know, Judge, that he was in possession of drugs. And very interesting, brought out on recross was, he told them. He said, yeah, 20 minutes ago, I used cocaine. Judge, it's possession of cocaine, not the something. That's circuit court level. If so, I'm going to learn something new today. Thank you, Ron.
Counsel?
Yes, Judge. The defense had presented, Your Honor, with the statute, 333 civil procedure. So section 3A is a Good Samaritan, exception to simple possession prosecution. Judge, that exception requires that the police are there for a medical emergency because of drugs. That is reflected in her report, that is reflected in her direct, testimony that the people are, quite honestly ignoring. She found a cat meal and a lotto ticket in his lap. He was slumped over not just because he was simply asleep, but because he had been using drugs. That was an inference of a drug overdose. The people had stated that, you know, that Officer Gardner had testified that my client had said that he had only used 20 minutes sooner, but she had also, excuse me, I'm sorry. She had testified that the 911 caller had said that this person had been slumped over the wheel for several hours. It is also required that the drugs are in a small quantity. When I made the stipulation to the laboratory, I did note for the record that it's about 1/4 of a gram of drugs. Less than 1 whole gram. And I'm sorry, I had a sugar packet for you, Judge, but a sugar packet, an equal packet, is 1 gram of drugs. Mr. Palmer had on him 1/4 of that. That is most certainly the amount of personal use. And it is a defense only to simple possession. So nothing about a kingpin, nothing about somebody who has a ton of drugs in their car. It is a statute or a law designed specifically for somebody in Mr. Palmer's situation. Police arrived because of that 911 call of an unconscious man. They find that unconscious man with needle in his mouth. They get him with medical attention. And they find a very small amount of drugs on him. And again, Judge, this is something that is designed for people just like Mr. Palmer, and as such, rule over dismissal. And I would also, I'm sorry, like to say, I'm looking forward to the field case that highlights this perfectly. This is People of the State of Michigan versus Justin Edward Duha. The LC number.
So how soon can you come up with $1,000 restitution, Mr. Johnson? No, I'm not giving you the end of the year.
Well, I was trying to follow the motion.
Okay, no, back up. You just said you wanted to file a motion. And I asked you, why didn't you file the motion? What stopped you from filing the motion you want to file? I've got a file now, so we can actually discuss this.
Okay, Ms. Johnson was, or Ms. Knapp was the attorney of record.
Okay?
The motion, regarding this, I have not seen it.
I don't think there was a formal motion, was there, Mr. Mohammed?
Where it was brought to attention that there's been a probation violation. So there was a hearing scheduled for today. Are we on the record?
Yeah, we're on the record. Let's get your appearances on the William Johnson file.
Good morning, Your Honor. Mohammed from the Mastiff.
Peter Verona, P7843, and I'm DC counsel for Michigan Township.
Thank you.
Your Honor, it's my understanding that the defendant has failed to pay the $1,000 restitution amount that was ordered by Your Honor. As you know, Your Honor, on March 18th, an order was generated, probation.
Right.
And it required the defendant to pay $1,000 in restitution within 60 days. It's now over 120 days.
Right.
Failed to pay that amount. It's my understanding, based off what's been brought to my attention,
You guys can sit down.
that the defendant has no intention on paying that $1,000. If there's one thing I've learned from this court, it's that the court speaks through its orders. The defendant failed to comply with the court's order. Additionally, at the last hearing, which I was not a part of, it was brought to my attention that the defendant had
I'm sorry. When you say the last hearing, you're talking about the March hearing?
June 25th, I believe.
Okay.
It was brought to my attention that the defendant had made comments to the victim despite the court's no contact order. It included profanity. It was brought to the attention of a court officer where he responded to the interaction. So the conduct that's being displayed by the defendant is a complete disregard for the court. Additionally, I was also advised that there was a PPO for this specific defendant by the victim in this case at the time that he had made those comments to her. Again, it was using profanity against her. I believe the exact comments were, "She is a broke ass bitch," is what he told her here in the court. So the complete disregard for the court system, the court's orders, to me suggests that this defendant's 771.1 status should be revoked immediately. And I think that the defendant's displaying this clear disregard for the court and Your Honor's orders. Your Honor, I think what's most appropriate is the consideration of a revocation of bond. I'll defer to your discretion. I trust your judgment, but that is something that I want to bring to your attention.
I don't have an independent memory from March 17th, and I'm going to ask you if you do. Was the restitution, part of the settlement discussion between defense and prosecution?
So Judge, I am relying on the register of actions as well as what was brought to my attention. I was not a part of the actual plea. It was my colleague who extended it.
Okay.
However, the plea form does indicate that people are seeking restitution. And if I recall correctly, on that specific date, I remember having a conversation with the victim and she advised me that it was to be ordered within 60 days. And I confirmed that by checking.
It absolutely was ordered within 60 days. My handwritten notes say that. The register of action says it was actually a discussion about how it was going to be paid. It was going to be with Zelle through the victim's father. So there had to be a fair amount of conversation about it on the 17th.
Yes.
Okay. Okay, anything else from the people at this point?
So we are here to move forward with taking testimony if it's necessary. The complaining witness is here. She would testify, as an offer of proof, she would testify to not being in receipt of any monetary damages, as well as the statements made by the defendant at the last court hearing. The court officer that observed part of the incident, I don't know if he knows exactly what was said, but he responded based off of his observation. He's present if necessary, so the people are prepared to move forward if necessary.
Okay, well, just so we're clear, one of the conditions of the delayed sentence was the restitution, but there was no order of no contact. So he might, not on the 17th, he may have violated a PPO, but I don't enforce PPOs.
I understand.
So today's issue is he was ordered to pay $1,000. It sounds like it hasn't been paid. So,
Thank you. If it pleases the court, I did talk to Mr. Johnson, and I was not obviously the.
yeah,
So I didn't see the actual order, it said within 60 days. He didn't recall that. The bottom line is that he has been paying in court. He has made about $250 to $300 worth of payments in the fines.
he wasn't supposed to pay us restitution.
Well, there was, I don't believe there was $500.
That's not what we're here for. The court costs are $500. We're here because of the restitution order.
I think there was a misunderstanding that he thought he could start paying the restitution when he finished paying the court.
Don't know. If he gave you that impression, then he's lying to you, because we distinctly said he would pay restitution through Zelle. This court doesn't take payments through Zelle. So he walked out of my courtroom knowing he was paying $1,000 through Zelle for restitution, and he owed us $500 for court costs.
I believe that one of the conditions, Your Honor, according to my, again, on information only, that one of the requirements was that he was supposed to get action, a list of what he was supposed to have taken that equals the $1,000. That list never came forward.
That was never part of my court order.
Judge, I believe that this is really a misunderstanding, and it's not, it wasn't deliberately not wanting to pay. He understands that he pled to this charge, and that when whatever the court ordered as a result of that plea agreement, that he is definitely committed to getting it done. I believe that he didn't make any comments to me that he didn't intend to pay the restitution. He basically said that he thought that he could start paying the restitution when the court was payment was complete, and then he would pay that restitution correctly to the complainant.
Then he came up with that all out of whole cloth, because he didn't get that from anything I told him. So how soon can you come up with $1,000 restitution, Mr. Johnson?
I'll say probably by the end of the year, but I did want to file that motion.
No, I'm not giving you the end of the year.
Well, I was trying to file a motion because the thing is.
Okay, what stopped you from filing the motion?
Stop me?
Yeah.
I didn't think I thought that's what this hearing was about.
No, you just said you wanted to file a motion. I said, what stopped you from filing the motion?
That this court gave, I'm not familiar with the terminology as far.
Okay, no, back up. You just said you wanted to file a motion. And I asked you, why didn't you file the motion? What stopped you from filing the motion you want to file?
This court gave.
Okay.
I'm supposed to be following the most.
Okay. All right, anything else before I deal with the violation of probation? Well, hold on, it's not a violation of probation, it's a violation of the terms of the delayed sentence. So terminology is clear.
Yes, and to that point, Your Honor, we would ask the court to maintain this deferred jurisdiction.
Absolutely not. What I'm getting out of this attitude I'm getting confirms everything I just heard from the prosecutor. So the conviction will enter and you'll pay the $1,000 restitution within 30 days or you'll do 30 days in jail. And you still owe the court money. And just for the record, he's had since March 17th to pay that restitution, and so far he's paid zero. Good day, gentlemen.
Your Honor, there's just one thing, if I may. Is it possible to add a no contact order between the defendant and the victim?
On top of the PPO that she's got from circuit court?
Just because I don't know too much about what's in the PPO and how long that's going to last, I just want to ensure that I'm doing what I can on our case. If that's okay, if not, I understand.
Your Honor, other than what counsel said regarding what was said at court, there's been no contact between my client and the complainant in any way, shape, or form. No postings on social media, no, contacting through friends, no direct contact, no text messages, no voicemails, nothing.
And that is correct, Judge. There's been no information brought to my attention that would suggest otherwise. It's just
Understood. Well, is there any reason to have contact with her?
No.
Then I'll order no contact because I'm going to lose jurisdiction on this case in 30 days. Because either the restitution will be paid and I'm done with the file because I've already terminated the delayed sentence. The conviction is entering, or he'll be going off to do his jail time. And either way, I'm done with the case. So I will say no contact for 30 days. Understand, ma'am? All right. Any questions? Good day.